Corporation, Transglobal Maritime Agency Incorporated, Goodwood Ship Management Pte. Ltd. and Michael Estaniel, petitioner versus Vicente D. Chua Jr. respondent. Before this court is the petition for review on certiorari filed by herein petitioners Transglobal Maritime Agency Incorporated, Goodwood Ship Management Pte. Ltd., Goodwood, and Michael Estaniel, sealing the decision and resolution dated July 20, 2015 and January 12, 2016, respectively, of the Court of the Appeals CE and CEGR SP number 133683. On March 20, 2012, Chua filed a complaint for illegal dismissal, non-payment of salary, withholding of documents, moral and exemplary damages, and author's fees against petitioners. Chua alleged that he and his companions returned later than their shore leave because of the problem with their contracted bicycle. They immediately went to the ship officer to return this passport and document. However, the ship captain was furious and asked to explain their tardiness. Chua also alleged that they declined to sign the written reprimand for and contained falsehood. They were perpetrated of February 2, 2012 without authorized and justifiable reason and without notice of termination. The petitioners, on the other hand, maintains that Chua was dismissed for just cause. His refusal to sign the written reprimand in a clear act of insubordination and disrespect towards superior officers. A general report regarding the incident was entered in the visa log, which Chua and the other also refused to sign. Petitioners allege that they agreed to be dismissed in the presence of Visal's master, chief officer, and chief engineer. In decision dated May 31, 2013, the labor arbiter LA ruled that Chua was discharged for just cause but was not served with the required notice of termination as he agreed to be dismissed. The LA observed that Chua failures to return to the ship on time for whatever reason constitutes the offense of failures to observe a regulation on the Standard Employment Contract POEA SEC, which provide the penalty of reprimand for first offense. However, his refusal to sign his receipt of written reprimand and a visa's logbook, despite being distracted by the visa master of superior officers, constitutes insubordination on offense with carries and a penalty of dismissal and payment of the cost of repetition and replacement, while Chua and other allegedly returned at 11:45 p.m. and not at 12 midnight, as specified in the reprimand letter. The fact remained that returned after the expiration of his shore leave. Since petitioners did not deny or respond to Chua's other money claims, the LA granted that same for its petitioners' burden to the prove their payment of salaries and benefits. The dispositive portion of the decision reads, were four premises considered: Transglobal Maritime Agency Incorporated, Goodwood Ship Management Pte. Ltd. Michael Estaniel are hereby ordered to pay quickly and severally. So ordered. In decision dated September 30, 2013, the National Labor Relations Commission in LRC unlock number 07000704-130 affirmed that the findings of the LA that Chua was legally dismissed but awarded no nominal damage for being dismissed without due process. The NLRC held that Choa's unreasonable refusal to receive the written reprimand was subtained by the visa logbook. In decision dated July 20, 2015, the CA granted the petition for certiorari filed by CHOA and reversed and set aside the decision of NLRC. The CA found that the NLRC overlooked pieces of evidence received from of the controversy. It held that while the order to sign the receipt of written reprimand may be lawful or reasonable, the same, however, does not pertain to Choa duty with his had been engaged to discharge. It ruled that Choa dismissal was disproportionate to the act complained of, that is his refusal to sign receipt of written reprimand. Also, the motion of reconsideration of resolution dated 31 March 2015 with a motion to admit copy of previously filed memorandum which was received by the court on 27 April 2015 is denied. So ordered, upon denial of its motion for reconsideration, the petitioners lived that case before this court, raising the following: the factual finding of the NLRC and the labor arbiter are binding on the Honorable Court of Appeals, absence any of the ju- jurisprudential jurisprudential expectation exceptions. Consequently, the conclusion that the dismissal of respondent was for just cause must be upheld and longer disturbed.